hearing into an application by Scottish Power Transmission plc made to Scottish ministers under Schedule 4 of the Electricity Act 1989 for what's known as the necessary way leave for the installation of an electricity transmission line over land at Bar Hill in South Ayrshire. I'm Frances McCleary, and I'm the reporter appointed through the Division of Planning and Environmental Appeals, that's the DPEA, to hold this hearing. Before we get fully underway, I think I'm able to see a number of people on my screen. We'll find out who everybody is shortly. If it should be that there begins to be problems with audibility, the only way to do it, to draw it to my attention, is by waving, I think, at the moment. So feel free to wave if you should have any problems at the moment. While we're talking, I mean, my coffee hasn't quite kicked in. Right, some important remarks about the data we're about to generate. Hearings under the Electricity Act are a public process, and this is being transmitted live to the web on the DPA website, where it will be accessible live and also for a period after the hearing is conducted. By your appearance and participation, you're deemed to be giving your consent to being filmed and transmitted in that way. Now, the DPA has detailed data management policies and practices which are available from the DPA website. Suffice it to say that the DPA will seek to use any data that we generate or collect in a responsible way, and it will not be retained by us any longer than is strictly necessary. Does anybody have any questions or concerns about the sheer process of a virtual hearing and it being published to the web? Any questions about that aspect? Right. Before we proceed, has everybody got a copy of the hearing agenda handy? Mr. Irving, you got it? Right, now the first step is to participate. Who's actually going to participate in the hearing? And I'm going to start with the applicants. Could we start with who's leading the applicant's case?
Yes, ma'am. My name's Murray Thompson. I'm a partner at Shepherd and Wedderburn LLP, and I'm instructed by Scottish Power Transmission. And my witnesses today are Neil Hardy, who's a transmission land officer.
Could Mr. Hardy indicate who he is by raising his hand? There we go,
yeah.
Right.
And by Marta Menchie, who's the lead engineer and project manager, and she's sitting immediately to Neil's left.
Yes, Miss Menchie, right, okay.
And if you need it for your records, Mark Peebles and Angus Niven from SP Energy Networks Legal are also here strictly observing.
Right, okay, I don't need to, if they're observing, I don't need them to identify themselves. Thing is, Mr. Thompson, I don't know, it's the way the camera's configured, I can't see you. I can see Ms. Hardy and Ms. Menchie, but I can't see you. Would it be possible to zoom out? Zooming out doesn't necessarily improve the situation, of course, because they get further away. You couldn't tilt the camera over a little bit to the, I don't know who's, I have no idea what's left and right your end.
Yeah, I'm not sure I can.
Right, okay. I can see.
Sorry.
Sorry.
Is it possible for the team at Thompson to speak up? For some reason, the sound is very, very low from there. From you, it's fine, but from the other team, it's very, very quiet.
Which suggests it might be their end that's the problem. If you can hear me, anything you can do, Mr. Thompson? After all, you must do these meetings much more frequently than I.
Well, there isn't anyone else who's actually speaking at the present time. We have a microphone which should pick up everybody once they are actually participating. It's really just me. As long as you can hear me at the moment, I'm the only one that is speaking.
Can you hear Mr. Thompson, Mr. and Mrs. Irving?
Is it possible to move the microphone nearer to Mr. Thompson?
Well, that sounds sensible. Could you do that?
Yeah, I'll do that.
Yanking it by its.
Is that better?
No.
Is there anything you can do about turning up your mic, Mr. Thompson? Another test. It's obviously crucial that Mr. and Mrs. Irving should hear you.
Yeah. Is it up full?
Right. Mr. Thompson, just introduce yourself again for testing purposes.
Yes, I'm Murray Thompson, partner at Shepherd and Wedderburn.
He sounds a little louder to me. Can you hear him, Mr. and Mrs. Irving?
He is a little louder, but it's very quiet.
Okay. Well, if that continues to be a difficulty, I need you to tell me, and we'll see what we can do about it. Mr. Thompson, if it should be the case that if you've got have you got anybody of a technical persuasion around the firm who might be able to assist if audibility is a problem your end?
Yes, I'm sure we can.
Okay, we'll have a go and we'll see how we get on. It's me that has to talk for quite a while. So next element of the agenda was the introduction of Mr. and Mrs. Irving, and I can see you quite clearly, Mr. and Mrs. Irving, so I've got you noted. Now, I'm going to turn to agenda item 1.3. So you seem to have got through the connectivity wars semi-unscathed. So, we begin with the statutory framework. This application has been made under the provisions of paragraph 6 of Schedule 4 of the Electricity Act 1989. In summary, as I'm sure you know, if a licence holder under the Act considers that they need to maintain or install an electric line and associated apparatus over line and they can't secure the consent of the landowner to that, they may apply to the Scottish ministers to ask ministers to grant them a compulsory right, which is known as a necessary way leave to take the line and the apparatus over land. The applicants, that's the applicants for the right, have to establish that it's necessary or expedient that the way leave be granted. That's key words, necessary or expedient, that the way leave be granted, and the primary onus lies with them to establish that that is the case. The objecting landowner has the right to oppose the application, and if they wish to be heard in relation to their objection, before the Scottish ministers decide on the application, and that's happened here. The ministers appoint a person to hold the hearing and then to report to them on the application and the objections and to make recommendations about the determination of the application. And that's my role. There's a couple of important details to bear in mind about what is relevant to the Schedule 4 tests of expediency or necessity. Scottish ministers have no remit to consider any issues relating to the level of any compensation which may be paid should the application be granted. That's because compensation is always part of the exclusive jurisdiction of the Lands Tribunal for Scotland. It's the way the system works. They won't have regard to the level of compensation. That means that the level of compensation is not relevant to the question of whether or not the application should be granted. I won't be hearing any evidence about that, and I won't be reporting to ministers about compensation levels because they cannot have regard to it. Does anybody have any questions about that? I think Mr. and Mrs. Irving, you'd mentioned compensation in your statement. Similarly, I don't think I'm going to find any of the negotiations or lack of them or how they were conducted to be relevant. This matter addresses the position as the applicants have defined their proposal, and it's up to them to justify the application as they propose it. Okay, that understood, everybody? Any questions about that? I think it's a good idea to get that aspect out of the way because it's always as you know, it's absolutely common sense that it's often in the back of people's minds, but it cannot be considered as part of the matters that are relevant to the way leave. Now, my objectives for the hearing, and I would ask everybody to bear this in mind, the purpose of the hearing is twofold. I want to hear what the parties have to say, but I also need to prepare, come away from the hearing with all the information I need to prepare a relevant and helpful report to allow ministers to make their decision. So I'll be asking questions where I need more information or to check that I fully understand the position. it's important that you help me about this. If there's something you're not sure I have, or if I'm misunderstanding, or if I've not caught up on, draw it to my attention. And remember, if you don't tell me, I won't know. Yeah, it's up to you to be sure that I have all the information I need. That being said, I already have your comprehensive hearing statements, and I have read all of these in your supporting documents carefully. I hope I have a grip on the background and the main thrust of both your cases. And I'll be taking all the written materials into account, even if we don't touch on them, refer to them, or discuss them in today's hearing. It's really helpful, though, as we go, if you indicate where in the documents that I have the information that you're referring to is. Tell me which document I'll find it in. And I'll be asking for these references as we go if you don't give them to me. By and large, hearings are always best spent focusing on the points of disagreement rather than rehearsing everything which is in the documents or the statements which is uncontested. So that's really how we want to spend our time. Now, how we're going to run this virtual hearing, how I'm going to run it. Basically, we're going to follow my agenda as the structure for the hearing. Hearings are sometimes described as a structured meeting of which the reporter is the chair. So rather than speaking directly to each other, questions should be directed through me, which sounds stilted, but it actually does work okay in practice. You say, if you want to ask a question, you say, Madam Reporter, can I ask Mr. Thompson such and such, or Miss Menchie such and such? It's just, it works out as kind of orientation if you approach it on that basis. In formulating the agenda for this case, I've taken a simple approach. I could have dealt with it on the basis of topics, but I've decided that the best way to do it was just to review all cases, approach it as a way of finding our way through both cases. So I want to focus on each case in turn and give both of you a chance to ask questions about the parts of the other side's case with which you disagree. I'll be trying to ensure as we go that everybody gets a chance to talk about everything that needs to be discussed. And if you have something more you want to say, speak up. However, after the hearing, I'll give you both an opportunity to go away and prepare a final statement which summarises your case in the light of what has come out in the hearing and anything which will emerge in the site visit. This concluding statement is not, and I would emphasise this, a chance to build a completely new case, introducing new topics. It's just a chance to gather your thoughts after the hearing and give me your concluding remarks in the light of the hearing evidence. I'll lay out the timescales for that in the site visit at the end of the hearing, but it will probably be a week to prepare it and a further week to respond to what your opponent has said. So the hearing is crucial, obviously, in the discussion, but you will have another chance to gather your thoughts together and make a concluding statement. It's important not to think you can sweep new things up in the concluding statement. It's just a good way of gathering everything together and making sure that I know exactly where you're coming from. Now, the pandemic years have meant that we've had many virtual hearings in a short time, and there's a couple of things that have emerged. We've found that it's a good idea to take a few more breaks than we normally do in in-person sessions, to allow everybody to take a break from the screens and gather their thoughts. So I will call breaks, quite short ones, 10 minutes, 15 minutes, at a convenient time through the hearing. If anybody needs a break for any reason, just ask me. The whole day has been set aside for this hearing. I would plan to call a lunch break for about an hour sometime between 12:30 and 1:30. However, we might find that we're making good progress this morning, and if we're firing through the topics we want to discuss more quickly, that's happening. We'll review progress and decide what we want to do. We might want to keep going rather than break for lunch. We'll see it once we get underway. My thinking about this hearing is that it will be unlikely to take more than a day. So my plan is to carry on until we've covered everything. I would be expecting to work on until we've done everything, even if we find ourselves unfinished by about 5 o'clock, or we'll just keep going until we've covered everything. But from my experience, I think we'll finish sometime mid-afternoon. Now this time, because I've been indisposed recently, I might be getting up from time to time just to stretch my hip. I have not had a chance to get down to Bar Hill and see the site first. I have had a look at it on Google Earth, and the applicants have supplied a photograph of it. It's a part of Ayrshire I know slightly, but not terribly well. So after the hearing, I want to carry out an accompanied site inspection. And we'll decide on the hearing after the hearing what I should see. The case officer, I think, let you know yesterday that I'd like to do this on. Ran some dates past you, and I think we've decided it's going to be Tuesday the 9th. Is that the case for everybody? Is everybody all right with that? Okay. Now, before we move on to move on to part 2 and looking at the case for the applicants, does anybody have any questions or points of clarification about the procedure for the hearing? Everybody feeling sufficiently talked at and sufficiently informed as to hope for the best? Right. Okay, so let us move on now to part 2 of the agenda, which is basically the case for the applicants. I'm going to summarise the applicant's case, Mr. Thompson. I thought I could do it briefly. It's turned out to be a little longer than I'd hoped. But if everybody would listen carefully to make sure that I've got the key points, remembering what I said, if it's in the written materials, I'll have read it. So in making the application, the applicants refer to their licence to carry out a range of activities under the Electricity Act. You point out that you've certain legal obligations derived from the statute and from your licence about how you must conduct your activities and your business. And you are the transmission licence holder for Central and Southern Scotland. I say you, Mr. Thompson, I do of course mean your clients. You say that you've been requested to provide a connection to the national grid to 2 approved wind farms. Kermorey Wind Farm, to be constructed near Bar Hill, and Stranach Wind Farm, to be constructed between New Luce and Bar Hill, to a new grid substation at Mark Hill, South Ayrshire. These lines are required, you say, to export the electricity generated by the wind farms to the national grid. You've supplied a plan with your original supporting 7, Appendix 7, which is SPT 1/7. Am I right in thinking that we'll see there the respective locations of these developments? Is that correct?
Yes, that's right.
In your hearing statement and supporting statement, you give details of what these 2 connections will entail and where the right lines will run. The proposed lines are indicated in some detail in, I think it's Appendix 6, the supporting statement, is that right? I got the appendix right then, yeah. Give some details of your design process, including the process of deciding on the route for these connections. You say that the routes for the lines which you've selected are the most direct and, in your view, the most economic and efficient, and further, the routes which will minimise the impact on the environment. Having selected the route in 2021, you submitted 3 applications to Scottish ministers under Section 37 of the 89 Act, which is the section dealing with permissions for lines. There will be a section which will be undergrounded, and this does not require a separate permission from ministers, as it would be covered by the operator's permitted development rights. You have explained the methodology used in selecting the route. You say this was done in accordance with your own guidance document, which was prepared in 2015. You say that the route selection process is influenced by the Halford rules. Generally, you say it reflects a hierarchical approach to routing, which first avoids major areas of the highest amenity, then avoids smaller areas of high amenity, and finally considers backdrops, woodland, and orientation. You've described the route selection process for connections from the wind farms in some detail. This took place commencing 2017, and it involved a process of environmental impact assessment, which that's correct, isn't it?
Environmental appraisal, it's not strictly EIA development, but there was an environmental appraisal carried out, which is short of a full EIA. Yeah,
but and in fact, I think it's the case that the approving authorities agreed that this was not a development which would require by law an environmental impact assessment. Did I pick that up correctly?
That's correct. It was screened negatively by the Scottish ministers.
Yeah, and you've made some extracts of your environmental appraisal available among your documents.
Yes.
You've also described the process of seeking planning permission from the local planning authority, and I think you've supplied 2 documents which reflect the report to members of South Ayrshire Council, and also the formal letter from the council in connection with the line.
On a point of clarification, the report from South Ayrshire Council and the letter, which was the resolution of the planning committee, is in their role as a consultee on the application for Section 37 consent and deemed planning permission. And that was their response back to Scottish ministers to
Fair point.
indicate they had no objections.
Yeah. Okay. You're quite right. So when I said seeking planning permission, it's really a statutory consultee.
Yes.
Right. Okay, thanks for that. Now, you've identified that part of the line which will need to go over part of the land owned by the objectors, Mr. and Mrs. Irving. And we can see what the route of that will be in the Way-leave site plan, which is document SPT1, Appendix 1. And I think we should have that to hand, which I did have to hand. That's this very simple document. I'm sure you all know it well, but that's, I think, the key, one of the important documents we would look at very closely. You tell us in your hearing statement in response that the length of the proposed overhead line forming part of the SBT apparatus, which is the subject of this application, is approximately 51 linear metres. The extent of the exclusion zone that you seek, that's the area shaded yellow on the Way-leave site plan, and over which you're seeking right to be exercised, is approximately 0.67 acres. I think Mr. and Mrs. Irving have used acreage, but we also have it in square metres. And I think, Mr. Thompson, you anticipate the use of an H pole to carry the line, is that correct?
Yes, it would be a trident H pole. It's illustrated in one of the documents, if that would be helpful.
Yeah, can you maybe give me the reference for that if you've got it handy?
It's within SPT2.
SPT2.
And it's within the second of the 2 appendices, technical appendices, technical appendix 2.2, and it's on page 20. And technical appendix 2.2 is the construction methodology, and it shows a typical H pole.
Right, that's very helpful to have that reference to hand. Right, good. And I think you actually say in SB2A, there's a quotation here. Poles may vary in height in order to respond to local topographical variations, engineering and safety considerations. You say it's not expected that the poles would vary more than 2 metres above the maximum stated height in this context, and where this occurs would be very limited in terms of the number of poles affected. The typical pole height above ground will be 12.1 metres for this connection. The assessments carried out for this appraisal, that you obviously mean the environmental appraisal, will have assumed typical pole height of 12.1 metres. The pole length range for trident wood poles is between 10 metres and 22 metres. Once foundation depth, which is 2.5 metres, is subtracted, and insulator height, which is 1.6 metres included, the range of heights above ground is 9.1 metres to 21.1 metres. For this project, the highest pole height above ground, and that's of course the whole project of all the lines, the highest pole height above ground is proposed to be 15.1 metres. Now, it may be not possible to answer this, but I wondered if you had any information about the likely height of the pole that you propose on the Irving's land.
Yes, that's likely to be 14 metres. Information. That information is also within document SPT2. Appendix 1 has got the poll schedule, and it's for your notes. It's SO51.
Right, good stuff. Now, you refer to the acronym ILA, Mr. Thompson, and that stands for Infrastructure Location Allowance. I'm not 100% clear if that's something that's if you like an internal phrase, or is that a phrase of art that's used more widely? Is that?
It's used by SPT and the other companies, but it's effectively the same in terms of its operation as a limit of deviation, which is probably a more common term, or micrositing.
Yeah, that was really what I wanted to suggest. The ILA, infrastructure allowance location, limit of deviation, and micrositing, they sort of mean the same thing, and that is, and correct me if I'm wrong, the kind of thing is almost like ground truthing, when the technical people begin to actually decide exactly where the poles are to go. That can result in the pole being at a different location from where it was previously indicated.
Yes, that's correct. It's effectively an environmentally led process. So if there are ground conditions which haven't been fully established, or if there are any protected species, or sometimes it's allow the transmission license holder to respond to a request from a landowner for a minor change in a position. It's to allow the H pole to be moved within certain prescribed limits, and in this case it's 50 metres longitudinally and 25 metres laterally. That is set out in the application for Section 37 consent.
Yeah, so that's good. That's summarised quite a lot of what I was going to go on to say. But what we should understand is, if we look at SPT 1.1, the Way-leave site plan, although the line and the pole are shown indicatively here as at a certain location within the yellow band, it's actually within the turquoise dotted line, isn't it?
Yes.
The micrositing process could mean, could it not, that other poles could be at different locations, and that the pole on the Irving's land could be at a different location?
It means that from the position that's actually indicated with the black dots, that it could move along the red line, or it could move either east or west, but only within the broken turquoise lines on each side of it. So it can move further west or to the left than it can to the right, because it's already quite close to the right-hand side of the field. But yes, in theory, but it's not expected that it would move substantially. It's more of a safeguard to ensure that the environmental effects can be minimised if required. It's a mitigation measure in large part.
All right. And I think you say that the micrositing, if I can call it that, is a phrase that's in my head for it, of the poles and tracks will be subject to review both by the environmental clerk of works for the project. Is that correct?
Yes, because although it's not EIA development as such, there is an environmental appraisal which reports on the environmental effects, and the ecological clerk of works would have to be satisfied that there was not going to be an increase in any of the effects, and to respond, for example, if there is evidence of protected species, for example, that need to be avoided. So the ecological clerk of works will lead that process and will ultimately sign off on any movement, any micrositing.
And if I pick you up correctly from what you're saying, that would also entail consultation with the landowner?
There would be discussions with the landowner, and in some cases, for example, if there is if a pole was close to a field boundary, for example, it may be that a landowner would have a request that it be moved, closer to the boundary or further away from the boundary. So it does allow a discussion or to be informed by the landowner's request, but ultimately it will be, as I say, largely environmentally led. So it will be led through the ecological clerk of works and through that process, and that will be the subject of we would expect there would be a condition about the appointment and the role of the clerk of works through any deemed planning condition.
Okay. Coming back to your main arguments, Mr. Thompson, you say that apart from being the most direct route, your proposed siting of the apparatus on Mr. and Mrs. Irving's land has been chosen at this stage to minimise interference with current activities on the land, and in your view will not have an unacceptable impact on its enjoyment. You do not consider that any adverse impact on the landowner's enjoyment of the line would be such as would lead ministers to refuse the way leave. That's, of course, in your opinion. And you emphasise the statutory tests of enjoyment and necessity, and you provide arguments as to why you consider that these are passed in this case. You suggest a way leave based on the Scottish Minister's template, but you request a couple of enhancements. And these are quite detailed, so I'll not go over them in detail, but if you would ensure that these are highlighted at a convenient point after you get to the end of the process, if you want me in my report, should I decide to recommend approval, to cover departures from the Minister's template, if you could remember to fully explain these in your concluding statement. Okay, applicants, have I sufficiently summarised your case? I know there's a lot more to it. That's the tip of the iceberg. But is there any key point in your case before I invite Mr. and Mrs. Irving to question you and your team? Is there any key point in that summary you would like to emphasise before we leave my summary?
The only thing I would mention is the minimum height, which would be 6.7 metres above the ground in the field, and that would be to ensure compliance with the ESQCR, which is a document before you, which is the Electricity Safety, Quality and Continuity Regulations. It's SPT 5. So that would be the minimum ground clearance from the conductors to the level of the field as it is.
Right, that's a helpful detail. Anything else, Mr. Thompson?
No, I think you've encapsulated the case very, very fairly.
Right, Mr. and Mrs. Irving, were you able to hear Mr. Thompson when he answered my questions?
Yes.
Yes, thank you.
Jolly good. Now, I've got some points of clarification actually before I hand Mr. Thompson and his team over to you. Mr. Thompson, the Section 37 applications to ministers, what's the current position with these?
They're still awaiting formal determination, but obviously with the South Ayrshire Council having responded as the relevant planning authority, that will be a substantial part of the Minister's considerations, but I don't have a timescale for the likely determination.
Okay, so would it be fair to say that what we're considering here today is prospective? They proceed on the assumption that you would use any rights that are granted to you only if the Section 37 applications are granted.
Yes, precisely.
Yeah, and if it should be the case that the applications are refused or adjusted by ministers in any way to change the route. Now, there are representations I see in the representation from South Ayrshire Council. If the applications for Section 37 applications for the line, if these were refused or adjusted, how might that, if that was to affect the land here, what would happen then? Would the way leave be used, or would it be withdrawn? What would you do, assuming it was granted?
Well, to go back to the representation that has been made by Bar Hill Community Council, which South Ayrshire made reference to, drew to the attention of Scottish ministers, that seeks a section of undergrounding which would also include the Irving's land. Now, for argument's sake, if ministers decided that there should not be an overhead line in that location, then there wouldn't be consent to install any overhead line, and therefore the way leave, there wouldn't be any right to put up an overhead line, and therefore the way leave would just fall. It just couldn't be implemented.
Yeah. Okay. All right. Okay. Thank you for that. Now, a slightly different point of clarification, and going back a little to something I summarised. When you're taking a view on impact on landowners, when the operator is taking a view, what criteria do you use in deciding what the degree of impact on a landowner occupier is acceptable or unacceptable? How do you reach your conclusion on what your impact on the land user would be?
Well, it really depends on the existing use of the land. It comes through the sort of routing methodology, which is set out in chapters 1 to 3, really, of the environmental appraisal. Is one of many considerations, which include consideration of the Halford rules, which also takes account of residential properties and residential areas. But it would really be driven by, the existing use of the land in this case, and the extent to which there was some incompatibility. But largely it's driven by the Halford rules and the SPEN's own routing guidance from 2015.
Okay.
In this case, obviously, account would have been taken of the fact that this is some distance from the residential property which is associated with the land. It's about 250 metres from the house itself. And the fact was that the routing was not in the middle of the field. It's been moved towards the right-hand side of the field to try and minimise any impact. There will ultimately be a visual impact, but in terms of the use of the land, it should be quite limited beyond the actual presence of the H-pole itself, which will inevitably sterilise the ground on which it is installed. But beyond that, with the ground clearance, existing use of the field should be able to continue as it is at the present.
Okay. Right, thanks. That was my points of clarification. So I think we'll now move on to questions from the Irvings. Now, Mr. and Mrs. Irving, this is your chance to test the applicant's case through questions. So off you go. Questions to the landowners. Sorry, questions to the applicants.
Madam Reporter, maybe ask Mr. Thompson. I don't quite understand their statutory testing for enjoyment of our land, and maybe we could have a bit more clarification of that, as we would like to say that we've never been asked what our enjoyment of our land is. So how would they know?
When you say you've never been asked, do you mean by the applicants?
That's right, yes.
So how would they know? How would you know, Mr. Thompson?
The land, all of the land is surveyed as part of the routing process, and the use of the land is obviously evaluated. Now, in this case, the account is taken of the sort of planning allocation. It's not development land. There aren't planning permissions in place. These all feature in the decision-making process. But to go back to the landowner's initial point, SPT requires to balance a number of different considerations, because obviously it has duties to be economic and efficient, and that is to ensure there is value for money for the electricity consumer. It also has to find or bring forward projects which are technically deliverable, and it also has duties to minimise environmental impacts, and that is derived in its Schedule 9 duties as set out in the hearing statement. And it really is a balance to try and strike a satisfactory balance between those competing considerations. And although there may not be an opportunity to consult every landowner before a route is actually finalised, I think in this case there was quite a degree of consultation with the Irvings and the predecessor owner of the property. Obviously, in some respects it's unfortunate that they took title in April 2019 after the routing process had begun, and therefore they may feel that decisions had already been taken, or they had less influence over the process. But certainly there was a lot of effort put into discussing the project with them, both in terms of visits to the property, answering questions, and in terms of the wider public consultation, which included the meetings both in May 2019 and also another community meeting at the end of October in that year. We have considered the comments about the existing use of the land that have been made through this process as well. We remain of the view that the line will not significantly affect the current use of the land. Any proposed use is obviously would have to be considered at that stage, but certainly in terms of the character of the land and the use to which it's put at the moment, it shouldn't change.
Any follow-up to that?
I didn't really hear a reply to what is the statutory test for enjoyment of land, or maybe I'm missing that.
Can I just ask you, can I just check, when you say the statutory test, Mrs. Irving, do you have a particular line in the either Schedule 4 or any of the regulations in mind? When you say the statutory test, what where would I see that in the actual legal provisions?
It was something Mr. Thompson referred to in his clarification of some of the points just now. He said we use the statutory tests for the enjoyment of the land. Right.
Mr. Thompson, what were you referring to there?
Well, I don't know if you've misheard. I was talking about the statutory tests, the statutory duties and licence obligations, but the statutory duties are the ones set out in Section 9 to be economic and efficient, and also in Schedule 9 to take account of impacts on the environment broadly and to minimise any adverse effects. So there isn't in short a statutory test which is aimed purely at the enjoyment of any land. There are certain provisions in Schedule 4 which, for example, prevent Scottish ministers from granting a necessary way leave over the curtilage of a residential property, obviously that an overhead line cannot, a necessary relief cannot be granted over somebody's garden or over their house. But there isn't a statutory test for enjoyment. It's really bound up in a consideration of the balancing of the various duties.
I mean, Mr. and Mrs. Irving, when lawyers use the word statutory, what they're really meaning is that there's something in the black letter law that actually uses those words. And I think from my knowledge of the very complex provisions in the Act, I don't think there is a statutory test about enjoyment of land as such. I could stand to be corrected if you're able to find it, but I don't think there's actually that formula. The statutory test that we have here is one of expediency or necessity for the line. That's the statutory test, but it's an example of a statutory test, and that's the key one that applies here. I don't know if that's helpful. It's intended to be guidance to you as to what statutory tests tends to mean.
Okay.
Madam Reporter, concerning the area of the land affected, there's been an assortment of dimensions put forth. In SPT 14 on page 90.
Right, SPT 14, page 90. SPT 14 will be that's the chapter 4 in the technical appendix 4. Right. Well, listen, could you hang on a moment, please? Because I'm going to get that up. All going well, I'm going to get that up on my big screen. It's not something I have as a written piece. Bear with me while I get through all the hurdles which computers put in our way before we can actually use them. So that's 16. I think I'm on the wrong track here. 16 is
14.
It's 19.
14.
19.
Got it. Getting warm. Big document, so now I'm waiting for it to download.
Is this the document that's or the page that's headed summary and next steps? Page
Chapter 4 and Appendix 4 to the environmental appraisal 777746536.
And it's page, did you say it was page 90, Mr. Irving?
90.
Right. I've got route options and preferred route.
Yes, the preferred route, excuse me, on the right-hand side of that page, marked in red, shows the preferred route coming across our land with a width of 450 metres.
Right, where do you get that figure from there, Mr. Irving?
There's a map with a red hatched preferred route on the right-hand side of page 90.
Have you scaled from that map, Mr. Irving?
No.
Where did you get the figure from then?
It's written on it.
So it is.
So that shows the route crossing us at 450-metre width. If we go to page
Right, bear with me till I get this thing. Can I get it? Right, so the corridor is shown there as 450 metres wide.
Yes.
Right, we've got there. That's a good example.
If we go
when you
to
make a
page
reference, the numbers then have to be tracked back to the actual thing so that I can see what you were talking about. And what your central point, and it's very easy to lose track of that as one is trying to find the document, but your central point is that there's been a number of quotations given to you about the extent of the land affected by the land. That's what the thrust of your question is that right?
Yes. So if we now go to page 62 of the same document.
Okay. Yeah, route options and preferred route.
Yes.
Yeah.
The bottom paragraph of that says a 60-metre wide way leave corridor around the overhead line would be agreed with the landowners.
Okay, so that's so, and if I have you correctly, Mr. Irving, you're wanting to know what the impact.
Yeah, sorry, there's another one as well. If we now come to the site plan with the yellow highlighted box with the turquoise borders on it that we were looking at earlier.
Yes.
That is only 50 metres wide. It doesn't have the power line running up the middle. The power line is actually, from scaling of the map, only 13 metres from our border.
Yeah.
So in terms of the area of our land which is affected, because I appreciate the pole itself is not a large area, but the way leave stroke exclusion zone that goes with it becomes significant.
Yes.
So what actually is it going to be?
Okay, that's your question, Mr. Thompson. What is the actual?
Yes, the land.
Hang on a second, Mr. Thompson. I think it's important to track Mr. Irving through these points. So if you could ensure that your explanation covers the references to the various different widths of corridors, in order that we have a note of their function.
The 450 metres was a routing corridor. That was not the proposed route. So within that corridor, the route would be refined to a much smaller area. So it was to allow for the route itself to respond to environmental sensitivities. So the 450 metres was an area which was considered prior to the application for Section 57% being made. The way leave corridor itself is intended to reflect the infrastructure location allowance on either side of the line, as well as an area for access, and that would be sought in certain cases if the land holding were to allow that in terms of its location. In this case, that's not the case. What has been sought in terms of this application is purely what is shown. The only land that's affected by the application is the land highlighted in yellow, which is both the land from the access itself, from the B road, and also the land between the broken black lines. And that land is, as you said earlier, ma'am, around 0.67 of an acre. So only the land which is yellow would be subject to the necessary way leave, but the only land that would be directly affected would be the H pole and the land below the conductors. But the exclusion zone and the area for access, that would be used in a sense to try and manage any activities purely to ensure that they did not prejudice the safe operation of the line. And it's not a prohibition, and SPT 16 is the terms and conditions which Scottish ministers are being invited to attach to the necessary way leave, and they make that clear that activities within the exclusion zone could be undertaken, or any land formations or building operations, as long as they were approved by SPT. So it's not a prohibition.
Mr. Irving, do you feel you understood that? Is there anything you want to clarify in what that response has involved?
Yes, I have unfortunately, it's a question relating to the map and the yellow area. We were doing ground truth measurements yesterday on the field, and 60 meters for the way leave, if that's the figure, plus potentially 25 meters for the ILA, takes us to 85 meters from our border. And on the map, that comes to the access gate that is marked.
Well, Mr. Thompson, can I just see if draw us back on my understanding of the situation? Because if I've misunderstood it, that's very important. As I understand the position, the ILA could not take the line out with the blue dotted lines.
Correct.
Does that help you, Mr. Irving?
Well, I appreciate the line will not go without the blue lines. However, the way leave, which is presumably 30 meters each side of the line, presumably will move with the line. So if the line moves to the western turquoise line, then the edge of the exclusion zone must be 30 meters beyond that, if I've understood correctly.
Mr. Thompson, can you clarify that point?
The exclusion zone is fixed in perpetuity, and that would be determined at the point the necessary way leave was granted, assuming that ministers decided to grant it. It's to allow the line to move essentially at the point of installation. But the boundaries of the area in yellow, the boundaries of the land which is to be subject to the rights, will not change. They are exactly as shown on the way leave site plan. In this case, there isn't the opportunity within the land to move the pole 25 meters to the east, because that is the boundary of the land in this case. But there is the opportunity to move it 25 meters to the west. But the actual boundaries of the exclusion zone are fixed as per this plan, and they won't change irrespective of where the actual Trident H pole eventually gets installed.
Mr. Thompson, how can that be if you need the exclusion zone? If the line should end up close to the eastern boundary, are you absolutely sure that you'll have enough yellow land to allow you?
Well, the necessary way leave can only attach to the land which is the subject of the application and which is owned by these landowners. So any other protections that were required would have to be sought from another party. But in this case, there is sufficient confidence in the environmental work which has been done, I think, to understand that.
Sorry, I said east. I mean, really, I should have said west. I beg your pardon. It's not that east, it's the other east, as they say. I really meant the western margin. That's, I appreciate you can't take it into the next door.
Yes.
Suppose the line were to move to the western turquoise line. I don't think your answer would change from what, if I understand you correctly, you're saying that the applicants have decided to go for the yellow land. They wouldn't be seeking more.
They wouldn't be seeking more. It wouldn't change.
Mr. Irving, have any follow-up to that?
So what actually is the proposed width of the exclusion zone?
Well, the exclusion zone, it's around, it's about 35 metres using a scale to the west, and to the east it's around 14 or 15 metres to the east. That's to the two broken black lines, which are the east and west boundaries of the exclusion zone.
So 50 metres, is that?
It's in total, it's about 50 metres, yes, but that's just scaling it from the plan.
Always a risky endeavour. We can have a look on the land and see where your black lines would be. Mr. Irving, carry on.
I think I'm done on that. Thank you. A question.
Just mention something though. Mr. Thompson has made the point. It's not a prohibition. So the words exclusion zone, I would suggest, perhaps a wee bit harsh. It's land over which the applicants are seeking certain enabling rights. It's not land from which you'll be kept off.
Madam Reporter, then may I ask a question about that, which I did we did put into our supporting statement 2, which was about the exclusion zone, and I think that is how it appears on the voluntary way leave applications, and then on the necessary way leave, I did comment that paragraph 6.3 says of the exclusion zone, the exclusion zone is required to protect the SPT apparatus from any interference and to ensure access along the overhead line section can be maintained. It would prevent the construction of any buildings or other erections which might restrict or prevent access to it, except with the approval of SPT. The exclusion zone does not represent a prohibition on development, but in that necessary way leave in the Appendix 5, document SPT 1 NW supporting statement completely contradicts this and says, from the date of this necessary way leave, no new buildings, other erections, workings or land formations should be constructed, placed or permitted, and no excavation activities should take place or be permitted within the exclusion zone between the broken black lines on the plan annexed and executed as relative hereto. And I have to say, on a personal level, that when we read that on the necessary way leave appendix, it was heart-stopping to think that, annoying as it has been that people want to come across our land, that there in black and white, they were then telling us basically that we couldn't use that part of the land, and that it was really concerning and just another stressful thing for us to deal with. However, Mr. Thompson then in his reply to our hearing statements said that that was never their intention. So it seems on one hand, we are allowed to carry on as per normal with SPT's approval, and then on the other hand, we couldn't. But then it felt like a throwaway statement that there was never any intention for us to not be able to do that without approval. But there it is in black and white in Appendix 5. And I wondered what he meant by that. Is it Appendix 5 or is it not?
Right. Mr. Thompson, would you respond to that?
Yes, as I made clear in the response document when SPT 16 was provided, which hopefully landowners will have read, it was never the intention to be a prohibition, and there would always have been a dialogue. But in order to respond to the particular points that were raised, the concerns or the doubts about how that process would operate in practice, the wording was added to make it absolutely explicit that with SPT's agreement, then some of these activities could potentially take place. And I think I would like to stress there's a difference between the use of the land as it will be used, at this point in time, and what the exclusion zone is intended to control, which is any activities which would prevent engineers from accessing the line or maintaining the line or repairing the line, or any activity which might lead to the ground clearance being reduced to a point where it puts the line or it puts SPT in breach of its ESQCR obligations. So it's really to safeguard. It's to safeguard the line from the point of view of the public or anybody on the land, and it's also to safeguard the operation of the line itself. But it's not to be seen as a sterilisation. It's not the land. The land is not being taken in that respect. It's really just a mechanism to control the activities or development on the land to ensure that the integrity of the overhead line is protected.
Could you give us some illustrations, perhaps, Mr. Thompson? What kind of situations do your clients encounter on land like this? You know, a countryside field, which might call into question the safety and security of the apparatus. What do people do?
Yes, well, there could be land raising, a land raising operation if the land is subject to waterlogging, for example, which would potentially reduce the ground clearance. Or in some cases, there might be some form of building, stable or an agricultural building, which was constructed close to or under the line, certainly in the vicinity of the line, or close enough that somebody could touch the line from the building itself. And it's really to ensure that vehicular access can be maintained should the line need to be repaired or the conductors replaced, and that basically the public or anybody on the land is protected. It's really to ensure that the ESQCR obligations can be met, can continue to be met.
Right, well, that was me trying to get a bit of a to try and give a sort of worked example, and it does. And classically, agendas for hearings never go exactly the way you think you would. And I had wanted to clarify the position about your intended. I think it's a horse shelter you have in mind, Mr. and Mrs. Irving. Is that right?
Yes, it was. Yeah,
a horse. So I think we can take from what Mr. Thompson has said that it may be problematic to construct a building in the exclusion zone. Have I got hold of the right idea, Mr. Thompson?
Well, it would be considered, but there are no proposals that I wasn't able to see any details of any building on the website.
I'm quite happy to pursue the line on an entirely hypothetical basis at the moment, Mr. Thompson. But what I'm so that's why the sense in which I'm asking the question. From what you've just said, it may be problematic if a building were to be constructed on the yellow exclusion zone.
It's possible. I think there would be more latitude once the line, or certainly once the line was actually installed, then at least the infrastructure location allowance, which is part of the overall mitigation, there would be more detail on that, so it wouldn't be compromised, and that could be affected by land or the movement of poles outside the land, because it could have a knock-on in terms of the spans on either side. But there would be more latitude to look at the effect of a building depending on its size and location.
So if I have you correctly, it would be much easier to answer the question if you knew for sure exactly where the line would be and the pole would be.
Yes, because if we were to prejudice that infrastructure location allowance at the moment, it would be premature, because it may compromise the environmental mitigation which the infrastructure location allowance is intended to facilitate.
So, but if I have you correctly, you're saying two things. First of all, that if it was suggested to your clients that a building be constructed within the yellow, the land which is currently shaded yellow, then you'd have to come out after the line was constructed to see what was proposed.
Yes, I think there would be more scope at that stage. It wouldn't be as prejudicial at that stage, but it would really depend very much on the height of the building, the location of the building, and its relationship to the line and to the access. I don't know. I mean, perhaps the landowners.
I mean, what you're really saying is it's possible, depending on siting and size, that your clients could, if a way leave was entered into your client, subject to your client's approvals, they'd have veto over it. It's not impossible that a shelter of some kind could be constructed within the yellow land. You say you're not ruling it out.
No, it would be considered. It would, as you say, the SPT would have a veto, and they would exercise the veto if they felt that the building was going to put the line and themselves in breach of the ESQCR obligations, which are really driven at safety.
So, Mr. and Mrs. Irving, do you feel you followed that discussion? Do you, as I understand it, what Mr. Thompson is acknowledging is that if a way leave were to be granted, it would give his clients a great deal of power over what you might wish to construct on the yellow shaded land. They'd have a veto. They'd have a veto. But he's also saying that depending on where the line ends up, and what you want to construct and the height of what you want to construct and where you want to construct it, it might still be possible to put a building on the yellow land. That's my understanding of what comes out of that discussion.
Yes, I do understand that, and do
you want to ask any follow-up questions about that?
I think really my point had been that the contradiction between what was in the necessary way leave statement and the appendix, one saying that with their approval, which also doesn't mean that we would get approval. It's saying that they're not preventing or restricting with their approval, but that doesn't say that they would say yes for something that we might like to do with the land. And the contradiction in Appendix 5, which actually states that we cannot build. So I would just like to point out, I don't think I have misunderstood what that appendix paragraph says. It definitely says that we would not be permitted, and that had been my question, that it was a contradiction to paragraphs really relating to, we could say the same thing but completely different. And so if the necessary way leave were granted with the appendix in place, we wouldn't know for sure which is it. Is it yes with possibly their agreement, or no because in the appendix it says no?
Well, I think to answer your question, and I hope I'm saying more or less what I have just said, they would have a lot of power, but in order to reassure you, they have introduced some new wording which makes it clear that they're not ruling it out, but they would need to have approval. And it is a veto. There's no sort of appeal mechanism. If you wanted to do anything in the yellow land, you'd have to ask them, and they could prevent you from doing it. They've introduced the new wording to make it clear that they would consider it.
I mean, if I can clarify, the Annex 5 has been superseded, and the SPT 16 is the wording which SPT is inviting Scottish ministers to grant. Those are the terms. So the wording is with the consent. So Annex 5 can be ignored for the current purposes.
So that was an entirely hypothetical set of questions about a building you might want to build on the yellow land. Mr. and Mrs. Irving, are you in a position to ask any specific questions about what you actually propose at this point? We was going to ask you about them later on, but if this is an opportunity to actually put a proposal to the applicants, if you have a concrete proposal that you in mind.
Mr. Thompson is correct in saying that when he would have looked, there was no planning application showing on the planning portal. There is now, and although I think whether he would agree or not, it's only our word for this, that actually there was a planning. We already have a shelter in the other end of the field, and we had to apply for permission for it because it's a movable shelter, and it had been our intention to have it down this end of the field, the end where they want to put the line across. And after a year of planning not getting back to us, I had rung and spoken to South Ayrshire Planning, and during COVID and all the things that were happening for the planning office, they admitted to having lost our planning application. So actually there had been a planning application in for that shelter for over 12 months. And since then, and having spoken to the planning office, we have had to apply and put another planning application in, which at the moment is under
consideration.
Under consideration. Now,
it's just that you haven't produced a copy of any plans that you'll have had to prepare for your planning application. You haven't put them in as documents.
No, because we haven't got the planning permission.
Well, you could still have indicated what you wanted to do.
Yes, we could have, yes.
I mean, I would certainly find it very helpful to know what you wanted to do on the land. It's one of the things I need to understand. And if you were professional people, I'd be giving you a real scolding for not having put it in, but you're not professional people. Now, Mr. Thompson, apparently there is at least a proposal before South Ayrshire Council, so it would be possible for me to see, if they were able to provide it to us, a copy of the plan that Mr. and Mrs. Irving have put in for their planning application. Would you object to me having regard to such a plan?
Well, I would like to see it myself and understand why it might have been put in the knowledge of the line being installed.
Well, yes. So you'd like to see it first, and that's perfectly reasonable. How easy would it be, Mr. and Mrs. Irving, for you to email a copy of that plan to my office, to the case officer? Would that be a thing you could do?
Yes, I can do that.
Would it be something you could literally do in a few minutes?
Yes, possibly a slightly longer view than a short view, but certainly
Yeah, well,
within a few minutes.
It has to go to my office. My office has to then email it to Mr. Thompson and to myself, and then Mr. Thompson has to have a look at it. Now, Mr. Thompson is quite correct. He has an opportunity. If you want to put in something late, even if I'm luring it in from you, then he has an opportunity to object to it. But it certainly seems to me to be important that I would understand where you had it in mind to put the shelter. You mentioned that you have a movable shelter on the land at the moment.
That's right.
So is it the same structure? Is this an idea? Is this you wanting to move your structure from where it is now to a new place?
It's the same structure, and the reason that there was no planning originally is because it is a movable structure. We had been told by the people that built it that we didn't need planning for it because it's movable.
Sorry to interrupt. I just want to focus on the fact that it sounds to me as if it would be possible for me to literally see this structure.
Yes.
When I visit your land.
Yes,
is that correct?
Yes.
Yeah.
Yeah.
Well, Mr. Thompson, it sounds to me as if it would be very helpful to know where the Irvings are minded to relocate this structure to, from my point of view. So I think what we'll do is when after we have a break, it's not time for one yet, it's just 11:22. I don't want to take a break yet. But when we break to get ready for the Irving's evidence, if I can call it that, before then, I'd like to have a copy of the plan that they've submitted to South Ayrshire Council. I appreciate it's not a planning permission, it's an indication, but that will let me see where they want to put the structure. And we'll get the Irvings to send it to my case officer. It's Laura, isn't it? It's Laura Walker, is my case officer. And I'll get Laura to send it over to yourselves. I won't look at it until you've had a chance to see it. But it sounds to me as if it's a document that would be rather useful to my report. So I think we'll leave it at that just now. Now that was an attempt. Theoretical questions are in this particular type of proceeding are always less helpful than concrete ones. So we'll talk about the horse shelter in concrete terms when we get to your evidence, and we'll leave the theoretical to one side just now. But I can absolutely see that this is going to be an important element of the case against the application is the constraint on the use of your land. Am I right in assuming that's one of your main concerns?
Yes.
Yeah. Right. Okay.
Sorry, Madam Report, can I excuse me, ask you just a subsidiary question to that?
Mm-hmm.
As I appreciate that it's not safe or viable for us to build a block of flats underneath the power lines. However, there must be specific constraints as to how high, how near we can build to the power lines. Would it be possible to have those made available so that were we to apply to build something, we know whether we are within acceptable constraints and we know whether SPT are being reasonable if they veto it? Otherwise, they could be having a bad Monday.
Mr. Thompson, do you? I know you have various sort of advice documents that you sometimes make available to land users. I've seen them in other cases. But do you have what Mr. Irving is asking for? Guidelines about structures under power lines?
Yes, there could be documentation made available in the event that the application is granted, so that would guide or inform the sort of parameters that would be applied. Yes.
Well, I was really speaking about something a bit more general. Is that I think if I understand Mr. Irving would like to be. I think Mr. Irving would actually like to be quite specific, but I think you're not in a position to be specific because we don't know where it will be. We don't know how high it'll be. So I was wondering if there was, a glossy brochure that you give to farmers or something that would give them an idea what in practice they should and shouldn't do near transmission lines. Do you have something like that handout?
Mr. Harvey might be in a position to comment.
Well, similarly, I think Mr. Irving's request for such information is reasonable. I also think it would help me understand the kind of parameters and the impact. So I think if you could try and see if such a thing is available, and again, similarly, it's something that the Irvings could see and look at. That's not too bad. We're at 11:30 and we only want 2 more bits of information. It's fairly par for the course. Could you see what you could do?
Yes.
Okay, and now, Mr. Irving, I think that might be as far as we can take that just now. Have you got further questions you want to ask the applicants? Anything?
Thank you.
Sorry, did you say you had any more questions?
No, thank you.
Are you sure?
Probably not relevant questions.
Well, no. Well, if they're irrelevant, then I'll just politely sweep them aside. But don't let that inhibit you. If you have a question you need to ask, run it past us, and if it's irrelevant, I'll let you know.
No.
Are you sure? Don't let the chance go.
One minor thing.
Which might not be relevant.
In reference, our document, reference 7, Murray Thompson, 9th of March 2022. It's an email. Mr. Thompson wrote, as anticipated, the list of demands is such that there's no scope whatsoever for a voluntary agreement.
Right, well, we see what Mr. Thompson meant. Do you want to know what Mr. Thompson meant by that?
Yes, please.
Mr. Thompson, could you explain what you were trying to convey in that email?
Well, it was really just to encapsulate the fact that there was never any negotiations undertaken in good faith, and that there was an in principle objection, and therefore the list of demands, such as that the free electricity was provided or the line was placed underground, there was never going to be a kind of meeting of minds. So it was really just to encapsulate the fact that the SIST was not utilised the way it was intended, that there was never going to be an agreement. So the list of demands was simply a shorthand for saying we're not going to be able to satisfy you.
And would it be fair to say that would be in your own and your client's judgment, Mr. Thompson? Is that right?
Well, it's a matter of fact that we're sitting here unnecessary relief hearing because a voluntary agreement is not is just not possible.
Yeah, but as expressed in that email, what you were saying, what you were really laying out, using, I think, perhaps language appropriate, to the professional situation, was the situation as you and your client saw it. You weren't.
Yes, because the energy consent unit will only grant assist for a limited period, and then they will review it if there is a genuine likelihood of some movement, some progress. And it was really just to let Caroline Brown know that really the whole thing was not going any further.
Yeah. So, Mr. and Mrs. Irving, I think what I understand from that is that you can appreciate that Mr. Thompson and his team deal with the consent unit day and daily. I think it'd be fair to say that what he was expressing in that email was that, in their opinion, they weren't going to be able to come to terms with you. So that's just what he was saying. It's quite baldly put, I don't think there was any intention to be insulting.
It was taken as such.
Right. Okay, Mr. Thompson, have you any further comment to make?
Oh, no, it was really just supposed to be factual in the circumstances.
It's fair to say, Mr. and Mrs. Irving, that at that point, he was entitled to take that view. Would you agree or disagree?
I disagree.
I would disagree.
So in
during
fact,
the meeting with Mr. Hardy, after considerable discussion, the question was asked, would there be anything? And the reply to would there be anything that we could progress the discussion was free electricity. And as 0.001% of the capacity coming across the land, that doesn't seem to me unreasonable.
well, it may not seem unreasonable from your perspective, but I think in the industry things are a wee bit more complicated. Mr. Thompson, would you like to highlight the potential, and things may have moved on since I last dealt with these kind of situations, but is it feasible for your clients to arrange for the Irvings to have free electricity?
No, it's not. They're not. They have a transmission license. They are not supplying or generating electricity, and therefore, what normally happens in a situation like this, the role of the generator who is wishing to be connected is normally to incentivize the landowners to enter into an agreement with SPT through a facilitation payment. So rather than provide anything else, there's usually an inducement to grant a servitude or grant a necessary way leave, grant a voluntary way leave to allow to remove the uncertainties and to ensure that all of the land rights are in place and therefore the connection can proceed. And that was undertaken in this case, but there was never any question of free electricity. That just wouldn't be within Scottish Power's gift.
Is there any other questions you want to ask about that, Mr. Irving, about the actual nuts and bolts of it?
No, thank you.
Nuts and bolts, lines and connectors. Any other questions, Mr. and Mrs. Irving?
No, thank you.
Nobody appreciates it better than I, from years and years of practice, that it is actually quite tiring, quite difficult to pull your thoughts together and to get to questions. It is my practice to cut a bit of slack for people who don't do this all the time professionally, within certain sensible limits. I may not be unfair to either side, but if you do think of something, and we will have a discussion about your own position shortly, but if you do think of something that you wanted to ask, raise it with me and we'll see if I feel it's appropriate for it to be asked at that time. I know it's very difficult to do. Now, that takes us to 11:30, and it's been quite a worthwhile discussion, I think. I think we'll take a slightly longer break than normal. I think we'll break till I think we'll resume at 12 o'clock. Now, in that period, I want everybody to be very busy. I would like, apart from the cup of coffee that you will definitely require, if you could email the plan that you submitted to the council. It doesn't need to be everything. I just want to know where on the land you wanted to relocate that shelter and what you've asked for. The plan would do. You don't need to send me a copy of the planning application. Email it to my case officer, Laura Walker. I'll put her on the alert that it's coming. And could you also email it to Mr. Thompson? I think you have his email address.
Yes. So direct to Mr. Thompson as well.
Direct to Mr. Thompson. Is that all right? Is anybody else you want it? Anyone else you want it to go?
No, that's fine.
That's fine.
That's fine.
So that's yourselves, and Now, the other thing, Mr. Irving asked whether there was any well, I asked for any handout that you usually give to, probably rural landowners, to give guidance about the kind of agricultural buildings or agricultural structures, and the relationship with those with transmission lines. That's the kind of thing I'm after. And there may be no such thing, but if you can see what you've got, and again, send that in. If you find it, send it in to Ms. Walker, and also send a copy to Mr. and Ms. Irving, and then we'll discuss when we resume at midday. That's what we'll deal with first, before we go on to my summary of the Irving's case, and we'll keep going for a while after that. Now, is everybody clear about what they're supposed to be doing? I think our practice is just to switch off cameras and microphones, but to leave the meeting open rather than closing the meeting down.
Yeah.
Callum, in my office, is that correct? If he's listening, he might not be listening. But that's what we do. So if you would just switch off your video and your microphones, and then we'll switch them back on at midday. Okay.
Thank you.
Thank you.
Right, thanks everybody. Midday then. Thank you. Hello, Mrs. Irving.
Hello.
Hello.
Just waiting on the big table. Conference room joining us. Hello, Mr. Thompson.
Hello.
Have you got both myself and Mr. and Mrs. Irving all right?
Yes.
Good stuff. Well, I'd like to congratulate everybody on their efficiency and the speed with which they responded to my instructions. Not used to that at all. So I have received from Laura Walker, forwarded on to me, an email from Mrs. Irving with 3 attachments. Have you got that, Mr. Thompson?
Yes, I have.
And have you had a chance to take a view on whether or not you would object to it being a new production for Mr. and Mrs. Irving?
We wouldn't have any objection to it being introduced as a document.
Right, good stuff. I think it's helpful for me to have that information. And you also have been able to provide a document. Just get it back up. Sorry. Have you received an email from Mr. Thompson, Mr. and Mrs. Irving?
Yes, we have.
And it's got a working note, which I must say was the sort of thing I was thinking of, although it might not be. I was thinking of something even simpler than this. But I don't know how much. Have you had an opportunity to review it at all?
Not properly.
Yeah. Well, from what you know about it, which is that it's a health and safety executive document about avoiding danger from overhead power lines, would you object to that becoming a new document for the applicants?
No, we wouldn't object.
Well, that's very helpful of everybody, and I think in due course I'll be asking you to give them numbers. I think we'll come back to Mr. and Mrs. Irving's documents when we get started on their evidence, because there's a wee bit of tidying up to be done. But Mr. Thompson, could you add that document to your document list?
Yes, we'll do.
Can you remind me what its number will be then?
It will be SPT 17.
17, yeah, right, good stuff. Well, that's really good. It gives me a wee chance to work more informed way with what is concerning everybody here. Right, now, so that having been beautifully tidied up, I'd like to come back to the agenda, and I think we are now at the end. No, we're not quite at the end. I have at 2.5 in my agenda an opportunity for the applicants to do a wee winding up statement at the end of the presentation of their case, just sort of to remind everybody where it's taken us. Do you want to avail yourself of that opportunity, Mr. Thompson?
Only really to, I suppose, reiterate that the line is requires to be delivered in fulfilment of SPT's licence duties, and in particular condition D4A, because National Grid has received connection requests from the operators of the 2 consented wind farms, and that there has been a very extensive routing and consultation process which commenced in 2017, and that SPT is satisfied that the routing process as set out within SPT document 2 does meet its Schedule 9 obligations and was informed by the Halford rules. which is not, it's not to take the most direct route, it's to take the most direct route, all other things being equal. And that's not to the exclusion of environmental considerations or, for example, the impact on forestry. And that SPT remain of the view that there are no grounds for withholding the necessary relief in this case in terms of its impact on the use and enjoyment of the land.
Okay, right, and I just remind everybody that it's not just what is said in the hearing that I'll be taking into account. It's also the written materials, and there are much more extensive submissions on these themes made by the applicants, which I'll be having regard to. Okay, anything else, Mr. Thompson? Can we move on to part two? Can we move on to part three? That is the case for the landowners. And you having anything else?
No.
Good stuff. Right now, as with same as I did for the applicants, Mr. and Mrs. Irving, I'm going to summarise your case as I understand it. So bear in mind that if I miss anything that you think is a really important out, you want to emphasise anything, mention it at the end of this account. But before I do that, you have actually submitted 2 additional documents that aren't on your current list. One of them I requested, and the other one you submitted with your supporting statement 2, and that was I think you refer to it as the photo, and that's the one where you have indicated to a proposed alternative route for the line.
Yes.
So I think that we need to give them numbers. If I can find them, have them handy. There they are. Yeah, the first one is, I think you refer to it as a photo, but I'd like to make that Irving number 9. That's. I want to not.
Sorry, of the ones just submitted. Yes, apologies.
No, this is the one. This is a document that you put in with your supporting statement 2.
No. Yes.
And I don't think you've given it a number before.
No, I hadn't. I called it. I gave it a name only.
Yeah. So I'd like to make that Irving number 9.
Yep.
Okay. And I asked you to submit, because you had referred to the Holford rules, so did the applicants actually. And you submitted the copy of the Holford rules that you had found and that you were referring to. So I'd like to make that Irving number 10. Okay with you?
Yes.
So we now have a new document from you, and that's these 3 plans. I'd like to just keep them together, because I don't think there's any reason to separate them out. So we'll make them Irving 11. Is that all right?
Yes.
Yep.
Okay. I think you'll see once you're used to how hearings proceed. It's terribly important to have wee references for documents, because otherwise you're sort of sunk when you're trying to find anything. And I will have something to say about your number 5 in a moment. Now, I'm going to summarise your case, Mr. and Mrs. Irving. But I wanted to ask you, do either of you have any relevant professional qualifications that I should have in the back of my mind? Have you got anything relevant in your way of professional qualifications? It's sometimes we've never met somebody before, as we often haven't, and they answer a question. It's sometimes coming from somebody who has a professional background in the particular field, and that gives a difference to the kind of way in which one takes the answer. But you haven't either of you got technical qualifications in electricity?
I'm an electrical electronic engineer.
See, there you go. There you go. I could try quite hard to get that out of you, Mr. Irving. So you actually are an electrical engineer?
Yes.
And are you still practicing, or are you retired?
No, still practicing.
And you've got nothing up your sleeve, Mrs. Irving, that's relevant?
No, not at all.
Good stuff. And I assume one can always tell actually, but so in the course of your professional activities, Mr. Irving, you'll know more than I do, no doubt, about some of the technicalities of surveying land for putting in apparatus. I should assume that knowledge on your part.
Yes.
No. I work in the electronics line, so I'm indoors, shall we say? So I don't go surveying.
Fair. Very fair, right? Well, I will not. But not from a position of complete ignorance. Put it that way.
Thank you.
Right. Okay. Now, I think from what you've said in your statement of case, you bought the land in the Dusk Valley with a view to your retirement, and I'm going to ask you some questions about that. I think you criticised the applicants for not being prepared to negotiate with you as you see it, and some of the tone and content of their communications with you. I think that's been part of your concern. Is that correct?
Yeah.
You say that the applicants' dealings with you have been unreasonable. I think you say unreasonable demands, and that their submissions contain a number of inaccuracies and contradictions. I want to be sure that I know exactly what you think these contradictions and inaccuracies are. But very importantly, I really want to know what effect you think any contradictions or inaccuracies should have on whether or not the way leave should be granted. You know, why does it matter if they've got a contradiction or an inaccuracy? I want you to be quite clear about why, how you think I should take account of that, and I want to be sure I know where these are. Now, you do refer to a document as your reference 5, which I think you might have compiled yourselves. You might have put that document together yourselves as a PDF.
Could I interrupt you, Madam Reporter? We've got a beautiful picture of your earring at the moment.
Oh, really?
You seem to have slipped sideways. That's better. Thank you.
Really nice of you to say. Can you see my face now?
Yes, thank you.
Sorry about that. Now, what I was saying was, yes, your document 5 is quite a big PDF with lots of things in it.
Yes.
And some of those things are already before us because they've been submitted by the applicants.
Yes.
And you've made a number of page references, and if I understand, it took a while to work out what these meant, but I think what you've been doing is you've had the PDF on screen and you've been using the numbers that the PDF assigns to the pages. Is that all correct?
Yes.
Right. If that document's quite difficult to navigate, so if you want to refer to it, you'll need to be very clear about really which document in the bundle it is that you're looking at if you want to refer to it.
Right.
Okay. Now, you refer to the applicant supporting statement, paragraph 1.6, and you make the opposing point that the line will be crossing the picturesque Dusk Valley. I don't know the Dusk Valley. It's not an area I know. And you consider that the lines will be highly visible and will not comply with the Halford rules. I'm going to be asking you to clarify for me which aspect of the Halford rules you consider the applicants have contravened. I need you to tell me that. You question how the applicants could get onto your land through a locked gate. I may have picked you up wrong, but it looks as if you've been contacted by a number of people, including the wind farm operators, which seemed confusing. Is that correct?
That is correct, yes.
You've had letters from everybody.
Yes.
And you take the view that the pole and the lines will prevent you from using the land around the pole and the lines. And you take the view that that's the best part of that parcel of land that you have.
That's correct.
Beside the river. You're concerned that notwithstanding the terms of the proposed way leave, the applicants are seeking the right to make substantial changes to the location of the apparatus post consent. I think if I have you correctly, that's concerning to you because you don't really feel that you know where the pole and the line will end up. Am I right about
That's
it?
correct, yes.
You consider that the application is excessive because it was formulated and submitted before at least one of the wind farms had been given consent, the Kilmorey wind farm. But I understand the position to be that both of these wind farms are now have consent. But you think, I'm not quite sure what you're saying there. Are you saying that it was premature of them to have started planning the route before the wind farm had consent?
In discussions and in the documents, at various stages, it's been said that when planning a route, SPT are not allowed to plan for future expansion. So they are not allowed to put in extra capacity in an underground line, for example. They can only plan, budget, build for the job in hand. And yet, for this line, they were planning and building for the job in hand plus expansion.
What do you want me to take from that? I was assuming it's
using one argument to justify 2 points of view. Either they can plan for future expansion or they can't. If they're saying they can, as they have for this line, then when they put in the underground power lines at the north end of the village, they could have planned for expansion then. There is implicit plan for expansion on the high voltage lines leaving the Bar Hill substation, because there is going to be electricity from at least 2 more wind farms now coming into that station, but no additional lines are required to transport the electricity out.
Where did you see the position that they're not allowed to plan for future capacity?
That was not a scene. That was in our first meeting with Neil Hardy, Brendan Tinney, and a neighbour and friend at our house here. And we all knew about the lines that go underground at the north end of the village, and we asked why hadn't they put in the capacity for the next lot of lines. And that is when we were told that they weren't allowed to plan for future development, if that's what you'd call it. And it just seemed
convenient argument.
No, just you would have thought with a bit of forethought it would have made it easier. Let's put it that way.
So what you're really saying is, if they were going to be undergrounding a section at the north end of the village, why didn't they start thinking then
Yes.
about the line?
Yes.
And take it to link up with that undergrounded section?
Yes. But they said that they weren't allowed to do that. Basically a contradiction, I suppose.
Okay, well, we'll see what Mr. Thompson wants to ask you about that. You don't feel that you've been consulted about the route? You don't feel you've been involved in a dialogue? Is that right?
Not at all.
You don't agree that the route over your land minimises the impact on the environment. You allude to the visualisations from the environmental appraisal, I should call it, as demonstrating that the lines will actually be pretty visible. Is that the point you want to? You question whether the applicant's position as regards the consent of other owners. You say, if I'm understanding the point you're making, you don't believe that the applicants have all the consents that they say they do.
Well, we know they don't have total consent, and they have mentioned that. But you said about that.
Yes.
It said that they are supposed to disclose that.
Other landowners we know have not given permission. As we are a landowner who hasn't given permission and are going through the necessary way leave process, it would seem reasonable that the other landowners who have not given permission will also be involved in the necessary way leave process.
Right, I didn't think that was the point you were making. I think you were saying, I think this is something you said, this is an opportunity to develop a more acceptable proposal. You're saying if they haven't got all these landowners, maybe they should be thinking again. Was that the point you were making?
Well, that was also the point I was making. Because if this many landowners are refusing, then maybe it's time to reconsider.
And in your rebuttal statement, which I'm moving on to now, that's your supporting statement 2, as you've called it, you offered up an alternative line which you showed in yellow, crossing the valley to the west of the village. And I think the point you make about that is that in your view is a direct route. If the direct route is really the criteria, and,
Yes.
and it compares, in comparison to that, the pink route, as you coloured it pink in your Irving number 9, is not a direct route.
Yes.
Is that the point you're making from that?
Yes.
Okay. And you do make the point, I think we've really dealt with it though, but you do make the point that you feel there should be some form of palpable compensation in kind, whereby you get an electricity supply for free if you are inconvenienced by a line over your land. You think that should be the case?
No. It was, I think that was in a way taken out of context. When Mr. Hardy was here during the SIST for further discussions, he said to us, is there anything that we could offer you that would make you change your mind? And what wasn't mentioned was that I said, in agreement with the majority of the village, we would like the lines to go underground across the valley. And my husband came up with what about if we had free electricity? So it was an answer to a direct question from Mr. Hardy, and having heard what Mr. Thompson said, which is fair enough that SPT don't supply electricity, I'm surprised that Mr. Hardy didn't say at the time, well, we don't supply electricity, so that's not going to happen. But he didn't say anything. So, it was done in good faith. We answered a question.
Yeah. So it was from your point of view, it was overstating it to say it was a throwaway line.
Yes, in a way, because it was, we didn't know he was going to ask us that. So,
Component of the case you're making against the way leave or anything.
Sorry, we missed part of that. You stopped. You.
It's not. I shouldn't regard it as a key component of your case against the way leave.
No.
Okay. So now, have I summarised fairly all the key points you want to make against the application? Is there anything that I haven't said that you would like to emphasise before I hand you over to Mr. Thompson for your questions? Anything else you want to emphasise?
I think only the fact that going back to the enjoyment of our land, that when we came here as pre-retirement, as you know, I have horses in the field, and I had plans for what I would like to do, one being an outdoor arena and a stable. And it's at that end of the field, which is the only flat, dry part of our field. The rest of our field is rather undulating and very boggy. And so that's, in our opinion, not from a grazing point of view, but from using it in other ways, is the prime part of our field. And we were never asked, have you got any future plans? It wasn't something that, no, we hadn't applied for applications, because maybe unlike some people, we do have to save up to afford these things. So it was something for the future that we would like to have had the opportunity to do.
Right. So a couple more questions then, Mrs. Irving. What you'd ideally like to do with the land is not just keep horses, but also engage in further equestrian activities. You'd like to have,
yes,
what do they call it, a menage or something?
Menage, yes.
Menage is a slightly different thing, only known to Glaswegians. Menage. So there we go. But you're not right. You're not ready to put these plans into implementation just at the
No,
moment.
because we have to have planning permission for a menage, and it's just beyond our financial boundaries at the moment, should we say?
Right now, I'm thinking about the extent of your riverside plot, and I did cross my. I wondered about it from the point of view of flooding. Is the land susceptible to flooding?
Yes, but not that end of the field. That's the whole point, is that is the one section of the field that is always dry or near enough dry and doesn't flood, because not only do we have wash from the hill behind us and the road, we also can sometimes get flooding from the river. But it's at the far end of the field, not down at
It's the west end, not
yeah,
the east end.
yeah.
So, sorry, say that again, Mr. Irving. What did you say there?
It's the west end of the field which is prone to flooding, rather than the east end.
And I think you said it was boggy.
Yes, at the far end of the field, it's very boggy. So lines going across there, that would have been okay, really.
Where is the horse shelter just now, approximately?
It's at the west end.
I see it, of course.
Yes.
So that must be on the damper ground.
No, because it's actually on the top of a mound on the slope.
And why do you want to move it down to the bottom end?
That was always our intention. It was built up there by the builders because it had easy access by the gate where they could come in and build it. And then we were going to have it moved down to the other end of the field. But we did want to move it and not just have it in one place, but the planning office won't allow that.
So the reason that the shelter is in the west end is because it was easy to construct it there.
Yes, that's right.
And was that before your ownership?
No, that was in
2020.
July 2020.
Yes, builders during the pandemic.
Yes.
Right. So I'm thinking that's your residence. Is it that's your residence?
You can't quite see it.
Sorry.
Come
No, you need-
across towards your face. Yes. The pink on the other side of the road
Yes,
is our
that's
residence.
Right. Your residence and your garden, presumably.
Yes.
Yes.
So is it possible? Would it be possible for you to see the lines on your land from your house?
I'm not sure.
Um,
We have two big trees in the front garden, so possibly not. But we will see them on the going across the valley. So
yeah. So that was my next question. So you're likely to be able to see that section of the line.
yes, we will see it. Yeah.
Yeah. Okay. Yeah. One of the points you make in your yeah, you describe your land holdings in your hearing statement. Land comprises. This is the applicant. Sorry, this is the applicant's describing your ownership situation, and I'm going to go over it to make sure that it's accurate and that I understand it correctly. The land, the site comprises two distinct parcels, land owned by you, separated by the B7027 as shown on the Way-370 site plan. The smaller parcel to the south of the road includes Guinea Cottage and its curtilage, along with an area of land on which a garage store has been constructed. And I mentioned planning permission. The larger parcel The north of the B7027 includes mixed-use agricultural fields. So that's what the applicants have described the larger pink slices as being mixed-use agricultural fields. Do you agree with that description?
I don't know.
Not sure.
Don't know what it means.
They
Sorry.
had referred to it as arable, but it is registered agricultural land. I wouldn't know about mixed use. I don't quite know what they mean by that.
Okay. Now, arable means you could grow something on it, and the applicants have described it as arable, and you've taken exception to that. Why do you take exception to it?
My understanding of arable is crops, and there are no crops grown on it.
Yeah, but where does that take us, Mr. Irving?
Nowhere other than
nowhere.
The exception just being
It's an inaccuracy in the
an irritation to be human.
If I have you correctly, you don't think it's fundamental that they've referred to it as arable land and in their description of it in a couple of places?
Well, I think that they should have got it correct. I think it's an inaccuracy during something like this. I think that it should be correct.
and I don't know, because for all we know, there could be one set of rules for crossing arable land, another set of rules for crossing grazing land.
If it sterilises the ground.
As things stand at the moment, you don't envisage attempting to use the land for growing crops?
No.
I think that's all I think that's my summary, my points of clarification. So I think we're ready now. Mr. Thompson, could you do you have any questions for Mr. and Mrs. Irving?
Yes, I have a number. The first one is really just to establish their position and whether it's accurate to say that the Irvings don't dispute the need for the connection, but rather their objection is about the route.
Are we to answer directly, or
yes, that's all of these are questions for you to ask.
Okay. No, it is not an object. I'm sorry. Can you repeat the question?
I'm just trying to establish whether you are challenging the need for the connection or whether it's the form of the connection and the route of the connection.
The route of the connection, basically.
Thank you. Can I ask on what terms you would be prepared to grant a voluntary way leave, if at all?
I think that would have to go back to the underground, which is something that the majority of the village had asked for or wanted. So I would have to say underground.
Can I ask about your document direct route, which is Irving number 9? Obviously, that you believe that's a more suitable route, or it's a route that you put forward for consideration as a better alternative. But are you aware that the route itself crosses over the top of at least 4 residential properties?
no? It was purely an illustration of what the direct route would be, because much was made of the proposed route being the most direct route, and it clearly isn't.
Can I just, sorry, Mr. Thompson, can I just clarify with you, Mr. Irving? I think you'll have remembered that there's a constraint for any way leave, whereby ministers may not grant a way leave over a residence. So, if I could just indicate, did you literally just take a pen across the map? You didn't think of...
Absolutely. It was purely an illustrative image. And I appreciate that there are houses and other things on that route over which a line could not pass. But it was an illustration.
Right, sorry, Mr. Thompson, carry on.
Thank you. In terms of the application for planning permission that was lodged, I think in July, or validated in July by the council, is there a particular reason why that is located under the route of the proposed overhead line?
No, that's just where the best part for it would be. And actually, when I had spoken to the planning office, I did tell them that that's where you had applied for a way leave for lines to go across our field. So I made sure they knew about that, and they said that that was not taken into consideration when a planning application came in. So whether that's the same for you, likewise, that any other applications are not taken into consideration, I don't know, but that's what we were told. And I did tell them that's where the line was, of which they were aware, but they said it wasn't taken into consideration. So
would you be prepared to relocate the shelter from that position if the Section 37 is granted? So if consent is granted for the installation of the overhead line along that alignment, would you still intend to go ahead with the shelter if you get planning permission?
Obviously not under overhead lines. I mean, don't misunderstand us. We do realise that, but to be fair to us, to support us, the overhead lines have not been given permission yet. We don't know whether they will be given permission, so we couldn't wait before putting in our application just to see whether you would get permission granted. So we can't put on hold some of the things that we want to do on the off chance that, all right, it's more than an off chance that you would get permission to put those overhead lines across. It can't stop us going forward with some of our plans, waiting to know what's going to happen with your plans. It works both ways, I suppose. But to actually answer your question, yes, we would move the shelter, but then we would have to apply for planning again. And I think, like we have been saying, where you have this yellow area marked, which we've been and measured out, it doesn't quite line up with our measuring and where you're going to be. So that's why we would want to know specifically where the constraints are of where we can put our shelter.
Thank you. We touched on the issue about prematurity and whether there could be a degree of what I might term future proofing when connections are made. And you indicated that it had been put to SPT that capacity could be built into connections, and we're told that that wasn't possible. Are you aware that SPT is obliged to bring forward proposals for a connection where an application has been made to National Grid as the system operator for a connection to the transmission system, whether the wind farm has consent or not.
No, we are not aware of detailed constraints for the planning of SPT's lines.
Are you aware of the duty that SPT has to be economic and efficient in terms of any proposals which it brings forward, and therefore it wouldn't be entitled to build in additional capacity for which no connection was required?
Yes, we're very aware. We've been told that on many an occasion.
Mr. Thompson, is the implication of your question that your clients aren't entitled to plan forward on a speculative basis? Is that putting it too strongly?
Well, yes, because that seemed to be the suggestion that that would run counter to the statutory duties which the company has. And I think this process shows that works effectively, in the sense that there was going to be a single connection and then it became a consolidated connection because that was more economic and efficient. So it shows the Section 9 duties actually working at first hand.
But you had to have an application to allow you to do that.
But, well, there has to be an application for a connection to the transmission system, which comes via National Grid in the first instance, and then National Grid contracts with SPT, so it's a sort of tripartite arrangement. But those applications for a connection can precede consent, whether it's planning permission or whether it's Section 36 consent. The next thing was, I think you said that the line would be highly visible, and I just wondered from where you feel that it would be highly visible, given you've said you don't think it will be visible from your property or from your house.
The line across our field from the front of our house, because we have 2 trees in the garden, would not be visible. It would be visible if we were, for instance, in our front garden. And the line isn't just across our land, it goes across the valley and up the other side, across in front of our house. And so that will be visible. It's all, I know this is one part of the line, but it's all part of a line from the wind farms to the substation. And that part will be very visible as well. And from the road. Coming down the road, we would be able to see it. Other people would be able to see it. I think those comments have been made anyway by our Hill Community Council. But
in terms of your own land, if just looking at your own land in isolation, is it from your front garden that you feel it would be visible?
yes, and when I'm in the field, I'll be able to see it because it's going across the field, which is also part of our property, our land, our home.
The other thing I wanted to touch on, you had lodged a copy of some extracts from the landscape and visual appraisal, which is document Irving 10. And I think you pointed out that the
Irving 10? Irving 10 is, I think Irving 10 is the Halford rules. Did you mean that?
Yes.
Yeah.
No, 10 is the figures, and I think 11 is the Halford rules.
11 is the plans of the shelter.
10 is the Holford rules.
So we
I'm
had
sorry.
sorry, we had the references to the various emails, the last of which was reference 8. Then we had the direct route, which was 9. Then we had extracts from the environmental appraisal.
Oh, that's true, Mr. Thompson, you're quite right. Mr. and Mrs. Irving, if you remember, you put in a number of documents with your supporting statement. I apologise, I should really have tidied that up at the same time. You included various illustrations taken from one of the appraisals. I should really have given that, I've got you to give that a number as well.
EA Volume 2.
And it's not, Mr. Thompson, you referred to it as Irving 10, but actually it's never been given a number because I forgot to clear that up.
Right.
I think, given that we've already allocated numbers, it had better jump to the end of the queue and perhaps be Irving 12. Do you follow that, Mr. and Mrs. Irving?
Yes, thank you.
So I think that was the only 2 things you put in with your supporting statement 2. You put in the direct route illustration and then a group of illustrations from the appraisal.
Yes.
And can we take all them together and make them Irving 12?
Yes.
Right. Sorry, I've in attempting to tidy up, I've merely caused more confusion. It's the so could you? Right. But could you perhaps carry on with your questioning about those, Mr. Thompson? Should I get them up on my screen? Would it be helpful to do that?
Well, yes, it's figure 5.12a and 5.12b. It's just really a point of clarification.
I think perhaps could you give me a moment until I just get them up on a screen of some screen or other. So where would my office have published them? I think it's all in one lot, isn't it? It's all in the rebuttal statement, isn't it? Which for some reason is not coming up correctly on my screen. Hang on a second until I find it, please. The problem is it's been for some reason it's been put up on using the public DPA website, and here we go. Got it.
That's what it is. That's living around it.
I'm having trouble finding it, Mr. Thompson. Could you carry on and ask your question? If it's a minor point of clarification, then I'll see whether I need to engage in a major exercise to find it.
Well, it was really in relation to the penultimate paragraph in the response document, and it states that it says page 12 photo montage shows the poles and lines clearly visible against the skyline. Missing from this are the current lines shown in the baseline photograph on page 11. And I just wanted to ask, the photograph in page 11 shows the existing 11 kilovolt line as it comes down towards the road. And then the following page is the photo montage which shows the new line, and the 11 kilovolt line has vanished. Do you understand that is not because it's been omitted for any other reason than it's going to be placed underground?
We have not been informed of the other lines being placed underground.
Only where it crossed, where both lines or where they crossed over, we were told that part would be underground. But other than that, no, we've never been informed that that whole line there would be underground.
It's a number of poles from the top of the hill down to across the B7027. So from pole 21 to 24, from pole 21 it will be placed underground, and that's why it's not shown in the photo montage, because at the moment it's part of the baseline because it exists. In the future, when this particular project, if that proceeds, then the 11 kilovolt line, those particular towers that you can see, or those particular wood poles will have been removed, and the overhead line undergrounded at that point. Is that something you were aware of?
No. And your point being, sorry.
No, it was really a point in relation to your. I think what you were trying to say was there was not only a failure to back cloth the new line, but there was going to be a degree of clutter from the overhead lines, and I just wondered whether the undergrounding was something that you had been made aware of.
No, only where the lines were due to cross. So where the new line was due to cross the existing line, we knew that that part would go underground, but there was no indication whether it was between two poles, or it just said where that crosses, which would imply it was just one short section, not the whole of that section. So that has never come up.
Sorry, Mr. Thompson, but are you accepting Mr. Thompson's explanation for the disappearance of some of the poles in the illustrations that you've chosen? Are you accepting that?
Yes.
Yes.
New information, but accepted.
It is, if you do want to follow up, it's within chapter 2 of the environmental appraisal, which is SPT2.
Okay. Carry on, Mr. Thompson.
I didn't have anything. I didn't have anything further.
Right, that's fine. And here we are at 12:51. So,
Sorry.
Excuse me, Madam Reporter, could Mr. Thompson just give us the exact number where it does state about those lines going underground? We missed the last bit, sorry.
It's paragraph 2.4 of SPT. It's in chapter 2 of SPT2.
We've got a paragraph 2.1, and then it goes on to 3.
This is document SPT2A, chapters 1 to 3. Is that correct?
Yes, and it's within paragraph 2.4, which is on page 2-3. So it should be in the same PDF that was sent to the reporter.
Oh, out of sync then, maybe. No? We don't have a 2.
We have a chapter 2 construction methodology, 2.1 description of overhead line. And then
the appendices you're looking at, they're the appendices rather than the chapter which precedes that. It's at the beginning of the document, maybe about 6 pages in.
I've now found a 2.4 in the table of contents.
However, Mr. and Mrs. Irving, if you're accepting that is actually what the proposal is, if we look at it in the context of the point you were seeking to make, then I think you can maybe take your time to find that reference. I'm not sure that it need necessarily detain us. You'd be able to.
Yeah.
And I've remembered that I'm going to be asking for a concluding statement. So if you should find, after you've had a look at it, there's something else you want to say about it, that may be relevant there. But Mr. Thompson was really trying to be helpful. He was telling you where you could see that.
Thank you, Mr. Thompson.
Right, now, sorry, Mr. Thompson, no further questions. You just say that, didn't you?
That's right, yes.
Right, now let me see. I don't think I've got any follow-up questions, actually. I think we've done quite well in terms of finding out things. Let me just think. No, I think we've got everything. So if we go moving forward in the agenda, just as I did for the applicants, at the end of your case, as it were, that's my summary and the questions. There's something, I want to give us a brief summary of what your position is after this at this point, just at this waymark as it is. Is there anything you want to do, say by way of summing up, or to mention something that you don't feel has been covered?
No, I think it's all been covered, thank you.
Right, well, you know what, that takes us to the end of the hearing itself, which I thought might happen. So I think we'll just fire ahead. And we're in part 4, concluding matters now. Now, Mr. and Mrs. Irving, this won't be something I dare say you've done very many times, if at all, before, but do you understand what I mean by a concluding statement, given what I said at the beginning?
Not really.
It's not an opportunity to have another go at the whole thing. It is not that.
And nothing new.
That made me very unhappy. But it is an opportunity to draw your thoughts together, to, if you like, represent your case, same substance, in the light of the information that's come out during the hearing. That's what a concluding submission is. Now, I don't want to extend this process. No matter what this 1967 rules say, I adopt modern practice on that, and that is to get simultaneous submissions, simultaneous exchange. There's not one party first, another party second. So my practice is to give about a week to both parties for the submission of the first concluding statement, and then these are exchanged. And then if you want to, you'll have about another week after that to pick up on any points which your opponent has made in their concluding statement that you want to say something about. So it's two rounds, a bit like the hearing statement, if anything. So main concluding statement after about a week, and then about a week later, if you want to, you can have a further opportunity to make comments on the other's written statement. Do you understand that process?
Yeah, thank you.
I've garbled it. What's really important for my purposes and for the decision which will be made by ministers, what's central to this is the test in Schedule 4, and that is whether the applicants have successfully demonstrated that it's either expedient or necessary that the line go over the land. And that is the key question which will be before ministers. The word expedient is usually, in this context, is usually taken to mean advantageous, which is basically the dictionary definition of it. And this necessary is obvious. There is some power, some limited powers for ministers to adjust the application. The applicants have fine-tuned their application. But if it is your position, Mr. and Mrs. Irving, that you wish ministers to fine-tune it, then you have to be sure to tell me how, so that I can examine that and take a view on it. So I would like both of you to give me your main concluding submission by 5 p.m. on Wednesday, the 10th of August. Okay, I'm postponing it to the 10th because of the site visit, which will take place on the 9th. So that will give you some opportunity to write it and then pick up and fine tune it if there's anything that emerges on the site visit. So 5 p.m. on the 9th. Mr. Thompson, does that give you and your team any difficulty?
No. we'll be able to comply
Mrs.
with
Irving, can you manage that okay?
Yes, you said 5 p.m. on the 10th, and then actually you just said 5 p.m. on the 9th.
Sorry?
It is the 10th?
It is the 10th, the day
10th.
after the site visit.
Thank you.
Now, if you want to make a second concluding submission, that's your concluding submission in response, I would like that to be with the DPA by Tuesday, the 16th of August. So not quite a week afterwards, just a day less. So what my objective being that all submissions would be concluded more or less 2 weeks after the hearing, and there's going to be no further exchanges. So that'll be the fat lady singing, as it were. Okay, everybody manage that?
Yes, thank you.
So we've agreed to meet on Tuesday at the site at about 12 noon. Now it's a narrow road, narrow Ayrshire road. Where do you suggest cars might safely be parked? There's no need to make provision from them on your own property or anything, but is there anywhere nearby that you think cars could go? Where could I put
On
my...
our own property would be the only place, really.
How many cars are planning?
Well, Mr. Thompson, what would who's coming from your side?
Well, Mr. Hardy will be present, and maybe one or two others. So it may be that maybe we could come in one car, leave a car somewhere else, and just arrive in one car.
Could you do that? Could you do that? And I've got a car, so we're asking you to, if you're sure about letting people park in your garden,
Yes,
then that'll be 2 cars. Do you manage that?
that's fine. Yes, absolutely fine.
That's very kind, and not not necessary. We could be sent anywhere you like. We could be sent to park in Bar Hill if you want, but that's very convenient if it's at your own property. Because apart from anything else, I don't need to get into your property, but I certainly want to see what the outlook is from your garden. So that's good. We'll all swing into your garden round about midday. Now, I think obviously we're going to perambulate round the field. Don't tell me waders are necessary. Well, a pair of stout shoes.
Wellies maybe, or good shoes. Yes.
Me and Wellies don't really agree, but stout shoes would do it, would they?
Yes, they would.
What I think I need to understand the field. I obviously want to have a look at your existing horse shelter, and I want to see where you'd like to relocate it to. And Mr. Thompson, I think I will need to have the extent of the various lines.
The infrastructure location allowance and the exclusion zone boundaries.
I think I'll need to have them indicated fairly clearly. So whoever's coming from your side should be fully equipped with scales and tapes and things. I don't think I need to see anything else, though. Is there anybody else making any suggestions about what I should see? As you said, that the direct line in Irving 9 is illustrative, and as it does seem to have a number of issues with it, I was not proposing to carry out a site visit for your yellow line, Mr. Irving. Is that okay?
That's fine. You might need more than stout shoes for that.
Yeah, and it would also be a rather nice walk. I wasn't proposing to do any such thing. So that's all, Mr. Thompson. Is there anything else you want me to see?
No, I think it all should be apparent. I mean, obviously, the use to which the remainder of the land is put, and the conditions, because reference has been made to how this is, the fact that this is seen as the best land, but I don't think we need to make such specific arrangements. We can probably view that when we're down there.
I was going to have a look. How are you for midges at the moment, Mr. and Mrs. Irving?
I'm fine, thank you.
Because they're waiting. Good. Right. Well, those arrangements having been made for the concluding submissions and the site visit, does anybody have any other matters that they wish to raise? Mr. and Mrs. Irving, do you have anything that you want to raise that we haven't covered?
No, I don't
No.
think so. Thank you.
Are you sure? Mr. Thompson, do you and your team have anything you wish to raise?
No, I don't think so.
Okay, well, in that case, I'll say thank you to everybody for your cooperation. There's a really, they're not easy, these virtual hearings, but I think we've demonstrated that we can, you can have a reasonable examination of the circumstances. But thank you for your cooperation, and I'll conclude the meeting.